Order. Good evening and welcome to the ZBA meeting. Tonight is November 10th. It's 7 p.m. and I would like to call the meeting to order. We'll begin with the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So we do have a quorum. Everybody is present. We have no public hearing, public notices tonight. Everyone has a copy of the minutes from October 22nd. They were emailed and they're in your folder. Did everyone get a chance to look at them? Any discussion on them?
Make a motion to approve the minutes of the October 22nd meeting.
Second.
All in favor?
Aye.
I'll abstain from that. I was not here.
I will also abstain from that. I was not here.
Motion carries. We have enough for that. We do have new business on our agenda. It is for a site plan review and a special use permit. This is through Lois Realty. It's an application for a site plan review on the property owned by Lois Realty. The property is located at 1737 US Route 9W, tax map number 144.1-42.1, and the same property location for the special use permit. And you are here to tell us a little bit about the project. Can you just state your name?
Mary Jackson, Lamont Engineer. So there's kind of two main points to this project. One is the part that connects to Miller Road. Was approved, I don't know, 2013 or 2014. They put the road base in, they put utilities in, they put the stormwater in. They put everything in except for the trailer and flat. We'd like to get approved to finish that. This bottom section right here, it's clouded if you look on the second page. We have to know the process for that. I don't know if you have to see this together or not, because the second part, which is up above, really does not have to be approved to finish the other part. So this meeting is more to discuss how we proceed forward and get both of these things done at once or one and the other. You guys can decide on that. The second part is the part of the land that he bought, which you guys saw last month or the month before.
That's all right.
He's just taking parcels that are unusable in the existing part and moving them to this new road that he wants to build. And this new road serves two purposes. One, to move these parcels over there and, you know, make more room in the normal part and put them up there. And this new road will be far less steep than the one that was going to connect as part of the old project that was approved. That old road was somewhere between 15 and 18% going up the hill. And he found it almost impossible to do. He built it, but after he built it, he said, I don't want to maintain this. So he wants to be able to, you know, with this, I can make it much longer, and we have a small stretch that's about 25 feet long, that's 15%, but the rest of it's 10, 8, 6. So a normal slope to the road. As part of that, with these parcels moving, you're going to need water and sewer and storm water in the new section, because you're introducing new impervious.
You said this new section, you wanted the access from Miller Road?
Well, it connects to both. It connects the whole park on one end to Miller Road. And gives him a second way to get off of the property that doesn't involve pulling onto the main road. Not the 9W. which I think if anybody's been there knows it's a tricky place to
Pretty
get out.
dangerous.
Yeah. I mean, see as you go through, it's just, that first sheet shows it all, obviously in less detail, but then you get to C21, it's just showing what was, this is the part that was approved. It pretty much shows it all on this plan. I don't know how to approach this, it's all there basically, except for the trailer. But can we just pull a building permit to finish that part?
Well, I'm imagining it has to go back through site plan review and everything. Council?
Yeah, I think, my understanding is there's a little bit of background on this and that, there were prior approvals that were granted at one point in time. But, really through, as I understand it, no fault of the applicant, they expired. And so that's what really has been, I think, the genesis of this. I'm not sure exactly where we'll leave it to the applicant to decide where they want to go with it, but as it stands now, my understanding is they're asking for both the special permit and the site plan. So at the end of the day, I don't know if there's a subdivision that's required.
Well, it's not a subdivision, it's a trailer park, so you're not creating any new legal parcels, you're just creating leased land.
So I don't know that there's any application for a subdivision. I think the board may want to consider the circumstances with respect to the road. That's a significant consideration, certainly for the applicant, as well as all of the residents and certainly the town. What is the plan with respect to the road? In terms of maintenance, maintaining the ingress and egress, fire safety, and things like that. It sounds like there might be an issue in terms of the slope, and I don't know if at this point in time there has been consideration of potentially a turnaround as far as a fire truck or for EMS, and I don't know if anybody's thought about any of those things.
You wouldn't need to, it connects to all the other roads, there's no dead end. They're all loops.
There's a boundary line adjustment as well, right?
That happened, yeah.
Okay.
That's what would make the second part of this possible, the moving the existing parcels over to the top and being able to make a much more passable road.
Right.
That was the whole goal of adding that land, was to be able to bring the road up and around much longer and less steep.
Property from the Lamberts.
But as it is, even if that part didn't happen, he still must have finished the part that he started. There is a road there, and it gets in and off of Miller Road just fine. It's just a connection point to the rest of the park that is really steep.
The other thing that may be of a big concern, DEC has changed a lot of stuff in regards to wetlands, and it's surrounded by wetlands. From 2013, when this application went, so much has changed with DEC, so I don't even know where their stand would be compared to from then when it was approved till now.
Well, it stays outside of, the DEC did go to the site. They have obviously verified that the wetlands are there, as the site says. And all the work that is outside of the 100-foot buffer doesn't affect anything DEC. It's the parts that need to be done. The stormwater, which was inside the buffer, is already done. So you're not affecting any of the wetlands or the buffer.
Anyone on the board have any other questions in reference to this?
Sounds like they gotta do it all over and do the secret thing and
Yeah.
simplify it and not go through, they gotta go through the whole secret.
So just treat it as one project and not separate it, because it's not gonna do anything.
Well, you're gonna have to do a site plan review on this whole thing, that's a given. But it is, technically, it is a new project, so many years have passed. So it's sort of like, it's null and void from the past project that you had. And we sort of start over.
No, not start over, I mean, all the utilities and roadway, all the stuff that's already there, I think, is there. You know, you're just approving putting the houses in.
Well, it still would have to go, it would be a coordinated review, it still would have to go to county, it would still have to go to all of that. And laws have changed since then. So what you put in 13 years ago may not be the spec or code for today's standards. That's not up to us to decide as far as, you know, that would be with whatever coordinated review, you know, going forward.
One other thing, as far as stormwater is concerned, they still have an open permit to finish the stormwater work they have on site. They don't have to reapproach that.
If we approach this as a new project, everything would start over. I don't know how anyone else on the board or what council's opinion is on that.
What I'm saying is I just hand you the permit that they have from DEC already to do the work they've been approved for.
I still think it would go back to them for review. And we definitely would bring it to our town designated engineer.
The proposed work, there's a significant amount of lands, or modification of the land, right? So.
Yes, on the upper section, absolutely, I understand that.
So then the stormwater would have to be looked at as an all
That's
part,
gonna be changing.
For sure.
right? So it would make sense to be reviewing the entire stormwater.
Yeah,
program.
that's what I was saying, I'm just trying to separate the two if it's possible. Because the bottom section was built all the way until he got to the houses, and I don't really understand why he stopped. But he did.
Yeah, and unfortunately for you, it is what it's.
Yeah.
I mean, I myself don't have a problem with accepting this application so that they can start on their end. I don't know how anyone else on the board. It's definitely a big project.
I could just make a recommendation, I think it might help the applicant to get the referral to the town designated engineer to some extent sooner rather than later. It may help them in terms of receiving a comment letter. I think that will help everyone really focus.
I have no problem forwarding it on to our town
This
designated.
plan set is preliminary, it's not a set I would recommend sending to the TDE. This was for discussion purposes, you know, showing what intends.
Do you have different plans or?
No, I'm just, that's what I mean, didn't wanna go, I'm not gonna fully design the whole thing and find out nobody thinks this is okay. You know, that's a lot of money wasted by my client, so. The ideas are all there, but you know, like the details need to be worked out as far as the stormwater, the outlets, the elevations. Proper labeling throughout the plans, just showing everything.
Yeah, I have no problem sending this on to our town designated engineer and, you know, anyone have anything else?
Right, because if we send it to them, they can review it. Even at this I know it's preliminary, but that'll be able to give you a better idea of what they're gonna be looking for on the final.
Sure, I'm just saying, like even the details don't actually match up all the stormwaters. That's what I'm saying, is there's one step, this needs to go one step further before I'd send it to TDE.
Okay.
Like I'll submit my next set of plans and that, and I'm be comfortable with that going.
Aaron, is there a model that you use when trailer parks do expansions in the past?
What do you mean by a model, like for what?
Site plan? No, is this 26 lots you're gonna have here?
There's gonna be no new lots.
These are all pre-approved?
Well, except for, yes, I mean, the ones that were pre-approved, I guess now become new lots again. But the ones in the new section, they're just getting moved from, you know, the pre-approved lots that were in the middle of the, let's see, you can see it on this plan. See it on the overall.
So you're taking away lots from up on top and,
Taking away lots from, yeah, I guess you call it on top, you're right. You know, the existing part that they're running right now. There's several vacant lots they don't build on because they think somebody else occupies it and wants to keep it. And there's a few of them that just don't work right, don't work well, and it's really crowded, and they wanna move them out. And that's what this is, so it doesn't change any of the flows to the sewer treatment plant or the water system flows. This is the same amount of trailers.
So all of these lots on the bottom, like all in the hundreds, that is what you're proposing.
Those, no, well, those are the ones that were, again, that's the gray area that were pre-approved. And all the work was done so the wastewater treatment plant was already adjusted to take all those flows.
So
The water system was already adjusted to take all those flows through DOH. And he just never put them in.
pre-approval matters on this at this point?
No, we'll have to submit a report that shows that stuff was done, I get it now, but.
So that's my question. So this new project that you want would encompass all of these lots that, as you're saying, were pre-approved, but this is what you want, is all of these 100 lots?
Yeah, those would be the only, now those are the only new ones, because the other ones are just relocated units.
On these maps, which are the ones that you're talking about relocating? Is that the R ones up top?
Yep. They're designated with R because they're being relocated from the existing.
And the ones that are to be relocated are the ones that have the X through the number.
Correct, and there's a little chart on the top left on C20 that shows which lots are being abandoned and what they're becoming.
Jason, what are the utility services for this in terms of the water and sanitary?
We have a sanitary system right down the middle road.
So it's a private system.
yes, Corn Hill wouldn't.
How about the water?
There's no municipal water.
So this is just one well, a series of wells for this?
It's a public well system, right? It has treatment and everything. It's another private system. Private
you have
system
private
for
system.
water and private system for sewer.
Good, okay.
And
So
they
when-
report to DOH every month. It's
When did the board last look at those on the last review?
12 years ago.
So that was in 2013.
Right.
So, yeah, so essentially, it's a new project from scratch, start to finish. This entire thing would have to be looked at. It's a big project.
I say most of the reporting on our end is just that it was done.
I definitely recommend sending this on to, but you don't want that at this point. You're not ready for that. You have
The
more.
top portion, no. I mean, I could give you the old plans that were approved just by themselves if you wanted to send that out.
Well, we would need new plans for what the current project
Yeah.
is going to encompass.
No, the top section was, it's at the concept level with the road grading, the storm water, and even the sewer and water.
So I guess you speak to your client and let him know that this has to really start over from start to finish.
That's what I assumed and told him. I was hoping for it.
Yeah, I don't want to waste your time.
Well, it's not, we just have to start over. Well, it's not, that's the thing. For him, it's not start over. We just kind of have to put a report together that shows what was done to the sewer, the water, that brought it up to the standard of being able to meet the flows that these trailers were going to add.
But that doesn't mean it's going to meet the standards for today. So that's why I'm saying it technically it's a completely new
I
project.
think that's what my report will say. I understand.
So I don't even know if it's really, there's nothing to go on. This isn't much of,
No, it was a preliminary meeting just to
okay.
see what you guys are going to require to get this to move forward.
Yeah.
No,
that would be our recommendation for you. So, anyone else have anything else on that?
I was trying to look up the code that me and Mr. Kinnery talked about that brought them in here. Because the project wasn't done in a 3-year time frame for the special use permit. And that's why they had to come back. I'm trying to find it right now.
I think that is the gist of it, though, that it's going to be a new project from start to finish. Do you want these back? Okay.
Aaron, do you need anything from us to?
Yeah, you accepted the application and now I just gotta move forward, right?
Well, we haven't accepted it. I'm not totally comfortable accepting it. I don't know about anyone else. It's not really
The application.
right. It's not complete. It's not really a project. This is going off of old stuff. You guys are gonna really have to present more of a plan for the new, so I'm not comfortable with that.
Okay.
Bill, can we give them a list of what we're looking for, or?
Yeah, I mean, to the extent you can amplify beyond what you've said, it's not a problem. It may be a bit of a challenge for you if you're not, because you appreciate looking at the right plans. But I mean, any issue spotting is definitely gonna help the applicant. So anything that you have, I feel free to suggest.
I mean, I would recommend having plans drawn up that are going to be reflective, especially with the new, we just did that lot line adjustment encompassing that with your new road that you have on there. Yeah. That would be my recommendation.
Well, the biggest part is I'll have to put together something for all the stuff that we've done. And prove that it met, or if it doesn't, say what we're gonna do to bring it up to code.
Yeah.
I mean, to Mr. Nolan's point, maybe a real good narrative to get the board to understand where they stand. That may help.
Yeah, I'll probably put together a report for the sewer and the water, showing how the flows are being treated and how they're being met. And the stormwater would have to be the same, so.
I am curious, when you proposed that last project in 2013, did they recommend a larger septic or another well to handle and support all of this?
Oh, yes, yeah.
Okay.
I know that was done, because they were 99% done. I just really, even asking the owner, I'm puzzled as to why they stopped and let this go past that threshold where they didn't complete it.
So that's a large piece of this puzzle too, to present that to the board, that you would need another well, you wouldn't need another septic, just more.
We just need to get it approved again. Because that was that all was put in, you know, there was more treatment put in, the flow was, I don't know if they put a new well in or if they put storage in this project, I don't remember exactly. But, you know, they had made the system capable of meeting demands for these trailers, both sewer and water.
And that was approved by Albany County, right?
That's correct.
So,
That's what you guys, I think, all need now, if that's gonna be treated as a completely new project.
Yeah. More information.
Yep.
Anything else?
All right.
And reach out to Jason, just anytime you're at a point where you have more, we can always send it on to our town designated.
Oh, yeah, we talked. That's what brought us here, just to kind of get everybody to see what happened there, you know, it's just.
This was already approved in 2013, correct?
Right.
So you just have to refresh everything and come back.
Yeah.
Changing a road.
Right, the road was changed,
Yeah.
there's more property.
90% of, not even, you know, that whole bottom section, yes, was already approved in 2013. But the upper section where the lot line adjustment occurred is where we want to move the old road, which is too steep, that portion of it, and bring it up there and around so that it's much more drivable and much more maintainable road.
There's just new laws in that. I mean, they just passed a new law, what, January with DEC, with the wetlands. We don't know how that's going to impact this now, so there's a lot to it. Thank you for
You're welcome.
coming in. Okay. So next on our agenda is old business, the site plan review and the special use permit for the Queemans PV, that's the solar project. That is an application for a site plan review on the property owned by Joyce Maxtad. That property is located at 1304-1322 State Route 143, tax map number 166.2-3.11. And that's the same address and property owner for the special use permit for Queemans PV. We recently received an email in reference to the water issue. Jeremy, did you want to talk more on that a little bit more? Yes, please.
So that, I just got permission from all the water department to share that section of email with you. So just to kind of prove our correspondence and the fact that we did actually receive this draft license agreement from the water department, in addition to the resolution that was approved by the water board. So, I mean, we'd really like to request that it's a condition of approval because we need this agreement to build this project separate from local use permit approval. Unfortunately, I'm doing my best to follow up with her weekly and try to get a solidified plan in place, but right now, speaking with her kind of preliminarily, it's looking like we're both reviewing decades of title information, and I couldn't find anything on my side, but I spoke with our landowner and she recalled one of like the original deeds from the 60s or something. So the water department attorney finds it hard to believe that there was no official landowner rights. So this would be the best option for all of us, but basically if there are established rights, we could use those rights as part of our lease agreement, so we wouldn't need anything, official. If that doesn't work out, she completely understood the draft license agreement is automatically renewed every year for 5 years. So that would get us through construction, but we need something that covers the life of the project. She completely agreed. She just said she's not familiar, so she has to figure out the best way to do it, because I guess they don't do this sort of thing very often. So we were leaning towards basically this temporary 5-year agreement that would transition with a whereas clause in that agreement to have a easement either permanent or over the life of the project. Unfortunately, with that plan, if the language in the deed doesn't help us, it just takes time. So, we need this to build the project anyway. I don't want to hold you all up. I don't know how long it's going to take, but, we're on it. It could be a month. It could be 2 months. And we're getting there, but, doing my best. So hopefully that gives you the confidence you need. And, are there any questions with that?
Well, sorry.
There's different things going on there, but don't we want paper? We don't want to email.
So I'm glad you said that your goal is long-term, because when I read this and it said 5 years, this needs to be for the life of this project. Because if or when you go to decommission, you need to know that you have access to that. So it definitely has to be for the life of the project. That's my 2 cents. I don't know.
I agree. And that attorney is the one that puts the idea of going from this temporary with a whereas clause to the permanent easement, just so we could get through basically permanent approvals and construction. That would give us more legal room to actually figure this out the way that is mutually beneficial. So we've had, great relationships so far, lots of correspondence, but she has to go through the board and the whole water department staff and see what's been done, where the precedent is with these kind of agreements. So, I think she's kind of working on her own with this. It's a lot of review. I'm trying to help her out, but the exact timeline's a little out of my control personally.
This is like being a little bit pregnant, though.
We're gonna have
They don't give it to you after 5 years.
They would. I mean, the temporary agreement would.
I don't think anyone on this board would go with they would. Like, that's something that has to be in writing, and it has to be, yeah.
The reason, yes, there's still uncertainty as to how that language pans out. The bottom line is we received the approval from the board. That's the hardest thing to get. That took over a year to get. So that authorizes an agreement. Now it's the fine details of what is this agreement exactly? How is that mutually beneficial? She's not inclined with that board approval to say, you know what, the board approved it, but we're not actually going to do this. I think that's very low risk.
Well, I think this board would be very inclined to tell you if it wasn't for the life of the project. So that's, I don't know how anyone else feels on that.
No, you can give somebody something, it's not just this. And okay, we're gonna approve it, and then maybe we'll make it permanent, and then it doesn't get permanent, it's like, okay, we got it anyway, in simple form.
Yeah.
What are you gonna do? So it wasn't right from the beginning. So that's the purpose of what we're trying to get to. We're not trying to pick on people here. We want it right from the beginning, so it's done right, and nobody ever goes back and says, well, why did it go like this? Who did this? We got stuff here today. It's like, who did this?
Well, and
You're actually protecting people.
I don't think
And it's not just this.
the fact that this was approved and the holdup was this water issue.
It never got approved.
Well, this board approved it, but it never happened because of that water issue. So, that's just something to definitely think about. Not to hold you up. At our last meeting, we agreed to extend this until the end of the month. So we do still have one more meeting. I mean, things can happen for you. Just to be honest with you, I did reach out to our town designated engineer today to get a little bit more clarity on, I know we've all spoken here about if we went forward with this, we definitely want protection on that cemetery. But exactly what does that look like? Details. Fencing, square, like the footage, how far from the site to it. So I did seek guidance as far as for verbiage and stuff like that from our town designated engineer. I do believe we did ask. I don't feel that we have a concrete plan from your company in reference to specifications, more.
That was included in the most recent civil plan that I shared with you.
So I want to know exactly how far it's going to be from your site, exactly what fence you're going to put around this. And I think we did request that we want a public access for the cemetery. Another thing is, something else that I asked our engineer is specifics on what a good plan that they could, for the mud, the dust, the dirt within that area. Work hours, I think that's something that we all have to discuss, which we've put that out there. The City of Albany, which we just said, and I feel comfortable in speaking. The decommissioning plan is cash. That's for me, that's non-negotiable. So.
Yeah, I understand the concern and the position. I did want to make one last stand for it. Unfortunately, I was out the last couple of meetings, but the long story short is, from our perspective, a surety company is a national institution with an A rating from S&P and Moody's. The chance of that going out of business, defaulting compared to any town, I guess I wanna make you comfortable and
So
just
there is a
truly-
chance, or is it guaranteed? You're gonna say there's a
There was a Great
chance.
Depression, so,
Okay,
you know, that
so-
would affect
so
towns
that's-
just like
So
national
normally,
institutions.
from all the years I have doing this stuff, if the chairs ask you to, something to go away, or board does, you should respect what they say. And there's a lot of issues here that I see, they're all vague, very vague. So I would be more precision on what you do and what you say, and give them the answers, and work with, I understand where you're coming from, you're doing a good job. And work with the board to get it done right, because we want it done right, and that's kind of where my head's at.
Council, do you have anything else?
A couple things, just for the board, try to get everybody focused on this if we're moving in this direction. We're gonna wanna know if the operator of the system or the owner of the property changes, so that will be incorporated. Be recommended that that's incorporated in the conditions, that the town would be apprised of that. My suggestion with respect to the cemetery in particular is that the board make a recommendation of the number of lineal feet. And that is the number of lineal feet from, and if you want to use one of the burial sites, that the construction perimeter will be X number of lineal feet. And then after the construction is completed, if you have a lesser lineal feet from the burial sites to a fence or some other, it's not so much mitigation, it's avoidance is what SHPO talks about. So the burial sites are avoided. So those would be recommendations, excuse me, with respect to the cemetery. One of the things I would also recommend that the board consider is the Trinity United Methodist Church. You have a number of considerations in that regard. Certainly the applicant has expressed a willingness to cooperate with the church, but in the first instance, I think the board should consider its work hours, the work hours of the project relative to the church's schedule. And I know some members have talked about special events. I do think that it's in the town's interests, the neighborhood's interest, the neighbor's interest, and certainly the applicant's interest to get this nailed down with some sufficient detail so that Jason and MJ doing the inspections on this are not confronted with 10 calls a day. But try to think ahead for what can make a better situation for everybody involved, and including the applicant. I think that there has to be some specs relative to perhaps noise, but I'm not as concerned about noise. It comes up from time to time. Noise relative to the church would be a consideration, but noise, dust, and then the roadway. I mean, if there's mud that ends up on that roadway, if they're in a construction season in March, you're going to want to have some foresight specs, if you will, to avoid those conditions. Again, all things that are routine, but the board should certainly be considering in moving forward. The water board license, I mean, it's sort of a work in process, as we've all seen. I think, ideally, it should be in place for the life of the project. Certainly, I think the applicant is striving for that. We'll just have to see. As I've read all the emails, I've seen how it's evolving. I think that there is a significant issue in the event as it stands now. The draft that the board has been provided does have a provision for termination of those rights. And so we've got to think through, okay, what's going to happen if those rights are unilaterally terminated by the Albany Water Board? And where does that leave everyone? Where does it leave the town in particular relative to decommissioning? If heaven forbid, that's where we go. And I don't mean to be the doomsday scenario, but we've got to think these things through because the applicant should be thinking about these things too, and I certainly think.
So there's no guarantee on that either.
No, as it stands now, there's a little bit of an opening there, and I think that, we would recommend that there be some notice provisions. If somebody's gonna try to modify that agreement, I think our code enforcement officer should be aware of that, so that these things don't just happen in the abstract, and the next thing is, there's an issue with respect to that, waterboard area crossing. The other thing that you should specify for the applicant, and I know it's been discussed, but I don't think that it was ever definitively pinned down, that my understanding is it's third-party inspections on this. So from the issuance of the building permit to the issuance of a certificate of completion, that it would be, and I'm not trying to presuppose it, but I think MJ would be doing those inspections. I think Mr. Nolan had noted that at one of the prior meetings. I would strongly recommend that if you all are inclined toward that be specified for the applicants so that they know. And then finally, the last but not least is, as you all know, the recommendation came back from the Albany County Planning Board on this, that I think it was modified subject to local approval. And I think we had at least 3 conditions that were specified in the County Planning Board approval, so it would be subject to those as well. And I think that's it, Madam Chairwoman, for now, but hopefully that helps the board pull some of this together to get a little bit of focus on at least what I sensed has been talked about in the last few meetings.
I was just pulling the Albany County Planning Board to remind everyone of that. The 3 recommendations, do you guys have them? One was a notice of intent filed with the New York State Department of DC affirming that a stormwater pollution prevention plan has been prepared and been implemented. Jenny did confirm that, so that would definitely be part of it. The other one was a decommissioning plan or established conditions requiring abandoned solar systems to be removed by the owner should be required to be included as part of an approval for this project, which you did have a plan for that, and we also, as I've mentioned to you many times, part of that plan is that cache. The other is the town should consider options to control the runoff from solar array that run downhill towards the creek. I did reach out, I called Danny Baker when we left our last meeting, and he felt, our highway department, Mr. Daniel Baker, he was very confident that the culvert that's there and with the runoff that it wasn't an issue. So I did want to confirm that, and I did. I don't mind speaking freely as far as, just so you have an idea of what maybe our expectations are. As far as ours, I don't know if anybody wants to discuss that, so he knows what we're thinking if we get there.
Jeremy, we just keep repeating ourselves every time you come here. If you had the water license to cross their water lines, I think we'd go forward pretty good.
I understand, and I get the concern, and we're partially held responsible for a company that went out of business for unknown reasons. I don't know anything about that company. We also, this is kind of separate from our perspective of local use permit approval. We absolutely need this to build it. So it's not like we get the local use permit and say, whatever to the Albany County water agreement, we're just gonna build it. We're not, we can't legally do that. We need this done one way or another. But I understand.
But even if we approve it, I mean, one of the conditions would be that water thing is permanent. So you're not getting that permit if you don't get that. So that's, now, I consider myself to be quite blunt, but if we put in a condition that cash, is that an option for your company? Because why waste your time, our time, if your company can't even do that?
No, we can do that.
Okay.
I wanted to make one last stand in defense of our company, but I guess with that said, I'm really just curious how the town typically handles these. Do you put it in an interest-bearing account, or?
That's my legal guy over there.
There's a protocol.
With inflation and.
Yep, it's all there. There's a protocol, it's contained in the town law. Queens has the same protocols. Probably can give you the citations, Jeremy, I just gotta find it.
It might have been shared in an email.
And just to, I'm looking at the civil plans, the most recent ones we shared with you, and I wanted to confirm that we do explicitly state what we're going to do with the cemetery during construction. So it's note 6, contractor to provide 25-foot buffer from existing cemetery during construction with orange snow fencing and signage to prevent inadvertent impacts to the cemetery. That language was taken from SHPO's recommendation, and it is explicitly marked on the plans. So I guess I'm wondering.
I also think we want a permanent plan for that cemetery. The snow fencing and stuff going there is fine, but we also want to know how far out from the tombstones that are there you're gonna go. And that's why I did reach out also to our engineer, so we have concrete numbers. You know, so as it was mentioned, so if you have 2 tombstones here, how far out from them are you going? I guess the perimeter. So more details as far as that goes.
Yeah, the most recent plan is, the one I have here is September 25. Is there a newer one than that or no?
There is a newer one. Sorry, a lot of emails came in. This one was October.
Got it. Yeah, I mean, because I see that note in here, but at least as of this one, yeah, as of this one, that actually may be what I have. I mean, it seems like most of the limits are all approximate. So I think.
Yes, they are, because the idea is when we get a building permit, you need to submit IFC set full construction plans that are very accurate. Which is, you know, at our current stage, we don't know what a construction company is gonna do exactly out in the field with these plans, so that really is an exchange for the building permit.
Okay.
Well, I think I want to know what that building company is going to be doing before they do it.
Well, I mean, approximate is very accurate, but they ensure that it's accurate, you know, as very accurate, so.
Based on aerial imagery, right?
Sorry?
It's based on aerial imagery.
This is based on site visits, surveys. So it is accurate, but just for building permit requirements, you submit a construction set. This is a pre-construction set. So by definition, be more, you know, approximate relative to a building permit construction set.
I did not go out on that site visit when you guys went.
Mm-hmm.
The grave markers are clearly there. So I don't see, if your company has gone out to the site, I don't see why they can't get exact numbers from the gravestones out to protect that.
We're marking exactly where things are from the survey and the site visit data, but the plans are approximate in nature until a construction company submits a construction set with a professional engineer stamp. This is, I guess, not, you know, coming not from an engineer, this is very accurate, but just, I guess, that is explicitly accurate for construction by the construction company. I don't expect that varying much. I mean, where we're marking the cemetery is where the cemetery is. And then they'll use that to say, okay, we have to be 25 feet for the solar plants. So yes, this should be accurate. I guess I hope you understand that.
Didn't we, Mr. Nolan, talk about something called GPR at one point? That was a ground penetrating radar, right? And that locates the burial sites so that you can definitively calculate the number of lineal feet from the edge of the burial site.
Yep.
That's not a bad option. So we can get our exact measurements. I don't know if you want to speak with and we could speak with MJ about having them conduct that if you would like.
Okay, yeah, I mean, realistically, I need to talk to.
That's fair.
See how it works exactly.
Yeah, that's fair.
Just so that the board knows, the deposit is under General Municipal Law 10. And under General Municipal Law 11, the security may be invested in special time deposit accounts or certificates of deposit issued by a bank or trust company located and authorized to do business within the state. Now, the security may also be invested in accordance with the following provisions under the law. The money is invested through a bank or trust company located and authorized to do business in the state. The bank or trust company arranges the deposit of the monies in the certificates of deposit in one or more banking institutions for the account of the town. The full amount of the principal and the accrued interest of each certificate of deposit must be insured by the FDIC. The bank or trust company acts as a custodian for the local government with respect to such certificates of deposit, and at the same time, the town's monies are deposited and the CDs are issued for the town. The bank or the trust company receives an amount of the deposits from the customer or other financial institution equal to or greater than the amount of monies invested by the town. So you segregate the town's investments. And then lastly, the question that typically comes up in these is, with respect to the time deposit or the CD, who receives the benefit of that, the interest? And the answer is, if the town properly complies with the law, the town does. So that's kind of procedurally how it works. And it does work in other municipalities as well.
We're going with cash, but you have a lot of years, I don't know if he was here for that. You've seen companies would go up, belly up the insurance. You'd got a lot of time.
He wants to remind me of my lot of years.
Yeah. I'll throw you down and I'll call it your
The
use
answer
of
is yes.
wisdom. So you've seen insurance companies
I have.
go belly up.
Yeah.
Well, I mean, cash is guaranteed.
Yeah.
There's no question in that. It's a protection for the town, it's a protection, so, you know, and I, to be fair and respectful, I think you've known our stand on that.
Yes.
For quite some time. So I would speak to whoever you have to speak to on your end. I will reach out to MJ tomorrow about possibly doing this at the cemetery.
I guess, I mean, one last point with that, I mean, these are kind of preliminary plans for special use permit site plan approval. For the building permit, there's a very explicit rule book of what we need to submit to get the building permit. I don't know what's gonna change between now and the next meeting. We've, you know, marked everything as required by the zoning code and the solar law. So, I mean, that's really handled by the actual person who's gonna build the project, the construction company, in exchange for the building permit. So,
Who is your construction company?
we don't have that yet confirmed.
Doesn't the building department generally, in the field inspections, determine whether or not that which has been built is consistent with the approved plans, the site plans at the planning board?
Yes.
So I think we just need to kind of focus on that in terms of what's approved here, where the sheets and the detail is generally what is checked in the field. So the compare is what's in the ground versus what was approved here. There are additional requirements to get a building permit, but deviating from approved plans requires a modification of the approval by this board, just so that we're all aligned in terms of thinking ahead.
So I guess I'm trying to think of the best example to kind of describe my point here, but the dimensions on the civil plan that we submitted are accurate, and we say in the notes to the contractor, this needs to be 25 feet, you know, from the gravestone, whatever it is. That 25 feet is going to be down to the centimeter, essentially. Right now, it's like, okay, maybe it's an inch off. You know, it's hard to say. Those are the kind of fine details that are hammered out in exchange for the building permit. But we do specify the dimensions that the contractor has to follow in the notes to the contractor, which is, you know, approved by the board. hopefully that makes sense.
No, it makes sense, but I think every single member on this board has been in agreement that we want to protect that burial site. And having a concrete plan on that, I think is important. Because depending on how we go, that is going to be a condition that is going to go into, if this were approved, that would be a condition. So approximate, here, there, I think you have to do a little bit better than that. And
That's why the building permit is different than special use permit and site plan approval.
we want to know what that exact plan is going to be though. And I'll talk to our engineer company tomorrow and she'll give a better understanding of it and she may be able to give a recommendation. I wrote a note to call her tomorrow, but speak to your people on your end in reference to that. Hundreds of years ago when they buried people, they might have buried them here, but their tombstone went there. So we just want to make sure that everything is protected. So, doing that imaging is not a bad idea to make sure. So hopefully we have more information. And I did go through that list with you as far as everything else that I emailed the engineer. Get more of a plan as far as the mud and all of that. As far as the board goes, like hours of operation, so he knows what we're looking at. I don't know what you guys, I know it was recommended by our highway department that not to run on weekends. I'm not opposed to that. It's a residential area. There's a church there. Just so you anticipate what we're thinking and talking about.
I think I'd give them a half a day on Saturday if they
Yeah.
have to, you know what I'm saying?
I mean, definitely not Sunday,
No.
but Saturday, I mean, that's not, I don't think it's prudent to think that they might work Saturday within reasonable hours.
Yeah.
And if the church does have a special event or something that comes up during the week, whether it's
Right.
burials, funerals and stuff, that has to be mindful of the church also. So those are just things to think about, for this whole board. So.
Jeremy, if we get to that point, you should be smiling.
I don't think we've put this much work, time, and effort with you. We just want to make sure it's done right and that there's a solid plan. So I'll find that out. I'll talk to Jenny, talk on your end, and we can email or call each other and go from there.
Sounds good.
Anyone else have any other questions or anything else for Jeremy? Council, do you have anything else? Okay.
Next meeting will be 25th?
Yes.
Right, okay.
Yeah, absolutely. Thank you, Jeremy. Our agenda.
You're out of here. Go to the back row and take a nap.
I don't even think that's working, is it? Okay, next on our agenda, we have old business. This is for the appeal for Mark and Michelle Dorsey. This is an appeal for the denied application for a change of occupancy on the property owned by Mark and Michelle Dorsey. This property is located at 880 Bridge Street, tax map number 131-4-12.1. Hi. Do you guys have any new information that you wanted to share with us before we proceed? The only thing that I was, can you just go to, sorry, just for the microphone. I don't even know if this, I think you're aware of this, but.
So I printed out, I went to tax map image me, right, online. So the property line goes through, Bethlehem is residential, farmland, right? That portion is actually zoned also residential commercial. So I have two, if you click on residential.
So Bethlehem is residential or commercial?
Humans.
Yes. And it's also like, I actually talked to the assessor, Lori, right, Lori?
Lori's in Bethlehem.
Yes. I just was asking her because the line, I'm like, how come the line goes to all the other properties? They're counted as Bethlehem. They're not counted as Queens, even though the line goes right through. The line goes through our property and we're counted for like two separate, I mean, it goes right through two farms. So if I want to do work on both farms, that farm says I don't need one, you guys don't even want to give me one, which this is a different farm, but I'm saying it's hard to like, the line goes right through two farms. She wasn't sure, she said, well, the zoning laws didn't come into effect until like the 60s or something, and I'm like, but this has been a parcel since the 1800s. I don't know
Thank you.
how that works, but the property in Queens also, I think it's in residential because they used to have those small houses
Thank you, sir.
for the college students, like little
Farms that were.
mobile units. But it was a commercial business. It was commercial and residential on the Queens portion. So like you said, like Rick Lessers in his letter, he had events there. He had an agriculture, like breeding horses is farming. Or he spent the whole day at an agritourism seminar in Saratoga. Well, it was this weekend. Breeding horses is farming. So they had, being a hospital is not farming, business. So, which breeding horses, agriculture is a business as well, but they had separate uses to this property. We're not veterinarians. That's all I want to point out. Is that how I'm paying taxes on this property is that it's considered commercial as well. So I don't know if that matters.
Is that like because you change your use? Things change?
That was before any changes. It was what it
Property tax was a 485.
So I just pulled this up. I'm on ImageMate right now. And it is listed as RA residential agriculture. That's the zoning. The reason this has commercial is that building, it says,
The small use building section, it's a property class code 485. So the assessor assigns property class codes to properties based upon what the prevailing use of the property is at that point in time, right? So generally, a single family house is going to be a 210. It's a single family residence. Apartments are 411s. There's clear definitions for what those property classifications codes are. They do change from time to time, and sometimes they don't get updated, right? You might have a house that was there and got torn down, and it still shows it as a residence, but it's actually a vacant lot. And I would say that is not any way, shape, or form permitting or allowing or granting a specific use of a property, right? People can choose to use their property in any way they want, whether it be legal or not. And just because I may be illegally using my property as an apartment in Queens Hollow, I should be assessed as an apartment because that's what it is. When you assess a property, you're valuing it based upon that use of property, right? That doesn't mean that it is permitted to be an apartment in Queens Hollow, right? We're talking two different sets of laws that govern different things. So assessments based upon the physical characteristics and use of that property at that point in time as a taxable status date. And the assessors trying their best to be accurate, right? And I will say that I work with the assessors and there's times that they are not accurate. And there's instances where property class codes need to be updated that don't get updated. So whether that's the case here, I don't know. But at some point in time, if there was a veterinarian facility there, that might be the 485, the one small use commercial building, that might be why it was there. I don't know. I'm speculating. But it doesn't mean that it's approved for that type of use. It's just that that's what had been valued as being there. Two separate different things.
it's only listing the building as commercial, not the property or the zoning.
Yeah, and so it doesn't have any impact on zoning, right? Zoning is based upon whatever was adopted by zoning by the municipality and then whatever is permitted within that zoning schedule, within town law.
So I had,
Business would be a commercial, wouldn't it? Business.
I am not familiar with what had happened back then, and I, Mr. Dorsey, I see your point, but I don't think it's necessarily relevant to what we're discussing today. Right, I think the point of the app is the appeal application, right?
Correct.
And I don't know if that has bearing on what we're discussing today, because what the appeal is to that change of use for the occupancy use of the Morton building, right? And I don't know what had happened when there was a veterinary hospital there, and there was probably a kid when that was happening, right? So.
3 years ago.
This happened 3 years ago.
3 years ago. You've been there 3 years ago.
Yeah, so they just moved to another location.
And we explained this the past 8 times we've been here. So I mean, it's been very clear what it was, what our intentions are.
Right, but what we're looking at is what's
And you're
from this
saying
point
that
forward, right?
And it's the same thing. What it was, to what it's gonna be. Still used as commercial.
Okay, but it's a residential agricultural district, right?
Well, it's residential. No houses on it.
It's based upon the zoning, that's what's permissible under law as to what those options of use are, right?
Also, what we were saying is, when he said you might have incorrectly, if you filled out a building permit, is that what you were told, building a building permit, right? And he was told to fill out a change of occupancy, but we don't think we needed one. Like, we were under the understanding that we're not gonna be a veterinary clinic, not that what we wanna do is not permitted. I would not have put any money into that if I thought it was not a permitted use at all.
Golf course.
Was it,
If you don't think that you.
CF1 zone.
Then would you do what had to be done?
different zone.
CF1.
No, I thought it was a permitted use.
You know what I'm saying?
So I just want, before we,
That's based upon the use, right?
I want to ask you a question from our last meeting when we had our public
I'm
hearing.
just going on what's on the website.
Right,
Right, so I'm looking at purchasing a property, I'm gonna go what's on the website. It says commercial.
that's based upon the assessment of the property, that's not, this image made online is providing assessment information, right? This is information that's coming directly from the assessor's files.
And it doesn't state that it's commercial. I'm looking at ImageMate right now. It says RA zone. I can show it to you on my end.
I get,
Make any
but I-
promises of permitted uses by providing that information, it's just.
Right.
I'm just going based on what I'm seeing, right? And it says commercial, and that's the golf course.
Yeah, because this is a different zone. This is zoned differently. This is a CF1.
It's an RA district though.
This is
RA
CF1.
district, I get that, it's
So,
zone CF1, but it's an RA,
community-
it's an RA district.
Community
No,
facility.
so that
We're- now we're-
residential versus commercial is what that actually is a reference to, is within RPS V4, which is the assessor's database. It's based upon the site characteristics that are used for evaluating that property. So you can either have residential or commercial, which is also included industrial. So depending on what the property is assessed as, then you have a different site, residential or commercial. It has nothing to do with zoning or what's permitted on the site. Again, this is just simply assessment information. It's not zoning and what's permitted or allowed to be done on a site. It's just this is used for property tax valuation purposes.
So, Ms. Dorsey, I wanted clarity on two things from you from our last meeting when we had the public hearing. At the public hearing, there was a letter read by Ms. Crisafulli on behalf of Mr. Lesser. He stated that he had a stone cottage on that property. Is that property accessible through your property or from Blodgett Road?
Doesn't matter.
Blodgett Road.
Because the letter was from him as a resident. When we have public hearings, we ask for addresses. I didn't get that.
It actually buffers our property. There was a road that went directly, like I could walk up to his house if I wanted to. But he bought Blodgett Hill so he could drive his car.
Okay, so that was my question, because when we have public hearings, we ask for the person to speak their name and give their address. I can't find any record of that house or that address, so that's why I was asking for.
It's not an address, like, it's
So
just
there's no mail to
a
it.
little cottage on a
Appraise that.
property.
Okay,
He doesn't live there.
my point to you is, it's someone who spoke on behalf as being a resident there, so I just wanted to get the address so I could enter it for, that was my question.
I think his address would probably be Blodgett Hill now, because when they merge those properties together, I think that's where his address would be. His property, but like,
Okay, that's fine. I can ask the tax assessor because it's not on the maps or anything, so, but I can ask the assessor, that's fine. My other, you had Mrs. Crisafulli was here also speaking. And I just wanted to point out for the record, she was speaking about the agritourism farm to table. I want to remind everyone, this is an appeal from the code enforcement officer had a denial for a change of occupancy. It is not a permitted use in that RA zone. The CEO explained that a use variance would be required. The agritourism town code chapter 165 zoning does not permit a banquet hall as a principal use or a special permit. We've reviewed all of the facts and the evidence presented to us from the CEO, everything that you've presented to us. We have plans. It's all for a banquet hall. The application states change of occupancy presented with plans for a banquet hall. I'm just giving to you the facts that this board has been presented with. The application that we have on hand never refers to agritourism, raising animals, providing equine therapy for veterans, hosting farm-to-table events, etc., as mentioned by you. The applicant we have in hand doesn't reference any of that. So none of that is relevant to your application. I want to stay focused. I want the board to stay focused. This is for a change of occupancy in an RA zone with plans for a banquet hall. Facts are facts. I'm just giving to you what we are presented with. We did hear back from Albany County.
The past 8 times coming here, asking for us to give information on what we're doing.
It
means nothing. You completely just wasted all of our time for the 8 meetings we come here.
We asked for information to support your application.
Let us know that ahead of time, because this is a waste of our time.
We asked for information supporting your application. I said, I think twice.
You said it's worth nothing.
It doesn't
support. Hearing for it.
It doesn't
we did an EFA.
If your application,
the county.
If your application was for, I think you said riding academy or something, then there may be more justification.
I think we need to do a new application and just not put change of use, because that should never, or change of occupancy, because I think Jason told Mark to fill out.
He's supposed to put it on there.
Ms. Dorsey, that was recommended to you before we sent this to county and before we got into this. I recommended that to you and to your attorney. Maybe pull the application and try to go a different path so that we can help you.
You're zero help. I've asked you the first meeting, what do we need to do? If this is the wrong process, what do we need to do? I asked you the first meeting, and I might have been the second meeting.
It has been stated to you 3 times, use variance.
That's,
IRC about,
Our attorney even said that when the meeting here.
I was advised to not do that.
Yeah.
this board never advised you not to do that. Your attorney may have advised you not to do that. Jason advised you to do that, and this board, I recall speaking, saying, if you want to pull this, you have the option to do that and then go that path. I'm just giving you the facts. We did hear back from county, because we told you we were sending it to county. County, I'm sorry?
We were there.
Correct, and we received the results from the county. Publicly, I'm just going to give that because that's, to be fair, Albany County deferred it back to us. So just wanted to report that for the record. So this board has, I only see 2 options. We can do a site visit and come out and see their barn and everything that is going on, if we'd like to, or we can act. Council, do you have anything further on this?
Just one procedural matter, Madam Chairwoman.
Can I beat you to it?
Yeah, you
Type
already
2.
read it, right.
We have to declare this as a type 2 action with no, it's exempt from review.
Right.
So I will make a motion to declare this as a type 2 action exempt from review.
I'm talking that.
All in favor?
Aye.
Opposed? Motion carries. So that makes everything complete on our end from start to finish for this. I'm asking all members of the board how you would like to proceed. Do you want to do a site visit and go out and see all of this? Or do we want to act on this?
Well, what would we hope to accomplish with this site visit, I guess?
It gives us more facts.
I wouldn't mind if you wanted to come see it. I actually had, Skill College. There's a lot of things, we looked for a building permit to finish the building project. That was it. We weren't like, this is our entire plan. Like I said, we're in 2 towns. I could have a building in one part of the town that it's,
I mean, 2
We
weeks ago,
definitely are
came
looking
here,
to
you
do
guys were worried about
agritourism.
traffic in Bethlehem. You have no jurisdiction over Bethlehem.
No, and I'm gonna be frank, I don't
I'm
necessarily,
just trying to wrap my head around all this, because I kind of do this for a living, right?
we don't keep, we don't keep
I'm just trying to
referencing
understand.
Bethlehem.
Huh?
We do not keep referencing Bethlehem. Bethlehem, we have no concern right now.
3 minutes ago, you were concerned about traffic,
We would have to do a traffic study for any kind of project. We would have to
the
do that.
roads in Bethlehem.
That
It's a
doesn't-
state road.
your application is not. And that's what matters. So we would have to do what's called a coordinated review.
Border, that is a property that we're talking about. What study are you doing?
So I don't know how you
You asked for it.
do.
It was a question on an application, if it would
An
make.
application, right?
It wouldn't make a difference. That's all we're
Not
trying
peanuts,
to
it
do.
wouldn't.
It wouldn't make a difference.
Not the peanuts.
Procedure, man.
It most
It
certainly
doesn't
would make a
matter. It's
difference.
what was on the application. And you marked no.
No,
well, we
because
don't
it doesn't
think it
affect
will.
We
people.
don't care.
Mr. Dorsey, to give you a perspective, I live in town of Queens. You know where I live. If I was going to
I
do
have no clue where you live.
Okay, not far from you. If I was going to do a big project and it was going to be an influx of traffic, yes, Bethlehem may need to be notified because if people are driving through Bethlehem to come to my house, it's going to affect it. So it does affect it. If that answers your
That's the
question.
crazy part of all this, right? The town of Bethlehem would love to have this. We would love to have- If this building was 200 foot the other way, north, Bethlehem would be ecstatic. They're all about farming. They're all about ag tourism. Right? They wish this was in our town. Right? Sunny Cobleskill, oh my God, Mark, this is a beautiful, you're doing a great thing. This is unbelievable. I can't believe you're having a hard time. I can't believe I'm having a hard time either. But
And
here
I
we
don't
are.
think anybody
Here
has
we are.
disagreed with you that your concept, but you have to go about it the right way, the legal
We spent 8
way,
meetings.
by getting
We
permits.
spent 8 meetings
That's what
coming
we're
here.
just trying to get is a permit.
And I did offer you the opportunity to
Put
pull
windows and doors
this
in.
about
Put windows
6
and
weeks
doors in.
ago.
I get a window permit.
So-
Put windows and doors in.
Can I ask each board member how you would like to proceed tonight? So we can give them an answer or go out and visit.
Please come out.
Mike, how would you like to proceed? I'm just gonna go right around.
I mean,
I don't think it matters if we go and visit. That's my
I-
own 2 cents.
yeah, I'm
So
kind of
I'm
the
ready
mind-
to act.
so I would be comfortable with acting.
Mr. Nolan?
I've walked that twice. It's a beautiful piece of property back out there. I love the cabin. I want the cabin out there.
Mr. Boomer?
I don't see where me personally, where a site visit is really gonna change. I mean, we saw prints, we've seen all kinds of stuff, so I mean,
The only thing we're acting on is the first application we had. And it was not about agritourism. It was about a wedding venue. That's what we're going on. That's what Jason denied. That's what we're voting on.
The venue falls under ag tourism.
Mr. Cronin?
I'd like to associate myself with Mr. Boomer's comments. I don't think anything will really change by seeing it physically.
Mr. Sinkyu?
I'm a little outside the box. If it would help them, I'm for it. But I don't know where I would go with that. But if it would help them, I'm for it.
Can I say one thing?
And
So-
you have a point too.
So when we went to the county, we talked to them, because I didn't really understand, like, that was like the quickest meeting. I was like, that's it? And she's like, this is beneficial, because we're just saying, we don't see a problem with what you want to do. So if you saw a problem with what you want to do, we would say something for them to like add in there, like you did with the other guy, you have to do these 3 things. They didn't see a problem with what we wanted to do. I think the confusion came in when Mark was told to do a change of occupancy, when we should really have put down there everything we want, our full vision, because you took a word from a print, which yes, I want to have weddings, but I want to do other things too. I want to have educational events. I could have a celebration of life. It's a beautiful space in an agricultural setting that we want to have farmers markets. We want to have eventually a little general store. We want to grow our own vegetables, and it's an evolving project. These 2 buildings already were there, they already existed. We wanted to use the space to be an open space for events. Take wedding venue out of it, an open space to have events. If that's, and it is permitted, like you're just at an agritourism conference, this is what is happening all over the place. I mean, if you want me to refill out a new building permit and not put change of occupancy, but listen, I want you to clarify this to be under a riding academy or a event. What was the other one? There's several things that it could have fallen under that terminology, you know?
Ms. Dorsey, I don't think anyone on here disagrees with you, but please understand, presenting us with plans that say banquet hall and also having a Facebook page that is promoting weddings and weddings only. A different picture is painted.
It's not promoting weddings. I've always said it's a working farm.
So,
And it doesn't, I've never had one event yet.
but just understand with the facts and the information that's been presented to the board. So
Other facts, and it seems like you're not even taking those in consideration.
we've been doing this for over 8 weeks. We've been
About
presenting information. The application has nothing to do with agritourism. I'm sorry to keep repeating that to you, but it doesn't. I am ready to make a motion to determine if our code enforcement officer, if his determination was correct on for this permit, for this application, that it does not fit in the RA zone. I want to get the right verbiage down for the record.
I'm interpreting what you're saying does not fit in the RA zone in that your motion is to affirm the determination of the code enforcement officer dated June 25th, 2025. I think I have the right date. That's the letter.
Oh, you got it up already?
June 25th.
Yes. Thank you.
If we deny this, they can come fill out another application?
Well, regardless of how we decide on it, if it does get denied, I don't want them leaving without us talking to them about what they can do to try to make this happen. Because that is not our end goal. And I sympathize with you on your frustration, but we can't go against the law, the code, the zone. So I'm going to make a motion to affirm the decision made by our code enforcement officer on June 25th, 2025 in reference to the application by Mark and Michelle Dorsey for the change of occupancy.
You're gonna deny the appeal.
Correct. That's affirming his decision. That's what my motion is for.
Second.
All in favor?
Aye.
I'm gonna abstain from it.
Abstain. Mr. McGuire, you are in favor?
Yes.
I'm just doing a roll call to make sure. Mr. Boomer?
Yes.
I'm in favor.
Yes.
Mr. Cronin and Mr. Sinkyu. Mr. Sinkyu?
Yeah, you could vote. No, as the alternate, you're voting because Bonnie's not here.
Are you a yay or a nay? A what?
No.
I didn't hear you.
Yay.
Yeah, yes. So the motion carries. Going forward. So you've been told by your attorney, and I think every single one of us sitting here has said, do a use variance. Your attorney said not to do it. Jason has said to do it, and all of us sitting here have done it. I went and spoke with Mr. Schmidt, who was chair on this board for many years, asking him if he's ever done a use variance. And I spoke to him weeks ago, long before this. And he said yes, and it was successful. Is it easy? Probably not. But there's a reason for it. If you want to have weddings there, you very well may need a sprinkler system that Albany County stipulates. This has to be done the right way. For your safety, this town's safety, and the board has to make sure that we do everything legit. I'm sorry, it's not what you wanted, and I understand that.
Is there a sprinkler system in the golf course?
I'm not speaking about the golf course right now. I'm speaking, and Mr. Dorsey, I want to help you.
So if I have weddings in the Bethlehem side, and those people at the wedding walk over the property lines of Queens?
Well, I'm sorry to tell you, your barn is not in the Bethlehem side, so that is null and void.
Special country. We have a wedding on the Bethlehem portion of our town.
Mr.
And
Dorsey,
the
I
wedding person walks over to the
can't
Queens side.
speak to issues in the town of Bethlehem. The Image Made Online is a product that my office pushes out, so I'm familiar with the information that's in there. So that's where I felt comfortable speaking about the assessment-related information, the difference between commercial and residential sites within RPS. I would echo Chair Grogan's sentiments. I don't think anybody here is opposed to a project along this lines. I think it just needs to go through the channels to actually get approved, based upon our code enforcement officers' point of view, and that we have affirmed this is not compliant within that zoning district as it was presented, right? I don't think anybody's opposed to this. Personally, I think this is my personal opinion, I think this is a great use for that property, but it's not the way to go about getting that permission. And I think from the beginning, we've discussed alternate options 8 weeks ago.
So you think that it is not, I don't want to keep honestly coming back and coming back and coming back. If your ultimate intention is like, I'm not going to approve this. Because I was told by our building
They have an axe to
department.
grind, I mean, especially
And
her. I
Mark,
mean, we come
stop.
here how many times, and this could have been what kind of panned out 7 sessions ago, right? Again, I'm a public servant, right? Right? My title, I could care less what my title is, but I'm a public servant. I try and help everybody that comes to me for help. This board here is not that in that case at all.
Mr. Dorsey, this board is not an economic development policy setting board. This is an administrative board.
The public policies wants ag
This
tourism.
is not a policy setting board. This is just looking at the facts in the law and acceptable uses.
I get that.
And the two of you have been sitting here for 8 weeks. We have a project that's been here for months. The last project that you just saw. We want to help you. If you can go through the right channel, nobody on this board is going to sit here and say, we're not going to pass it. We want to help you.
We should do the special, fill out that form.
Use variance. And if you call Jason, he'll even help you fill out the paperwork.
Mark asked him.
I went to him and asked him. He had no clue about it. Hey, man,
That is for you to fill out.
I asked you about 4 questions on there. You couldn't answer one of them.
So, Mr.
You
Dorsey,
came to him, asked for his help.
listen,
He was
I do
clueless.
not have an axe to grind with you. If you get the paperwork,
All the things
I can
he
help
asked us
you.
to do, he done.
I'll help you.
We're good. Let's help this not. Right?
Sorry, guys. Have a great night. Our next, we're not done, guys, so. Our next meeting is November 25th, right? Is it on there?
Yeah.
Now, that's a Tuesday. It's different. Because of the holiday and stuff, it was changed. So, does anyone have any other business before we conclude?
I just want to read off something quickly from the minutes of the September 24th meeting, because I think it's important and because it was pretty much challenged a couple times. Mr. Olson, that's I believe their attorney, stated that the applicants made a mistake in reference to their permit. They don't want a change of occupancy to use as a banquet hall. There's a miscommunication on their part. They can pull the appeal, get the right permits, and work it another way. Best option is to be upfront. Or the applicant could continue with the appeal, and the board could refer it to the county. So, again, just for our record and our purposes, that was given to them multiple times, both in private and before.
Thank you for that clarity.
Yeah, I don't get it.
And it will always be a change of occupancy because that is an assembly. And that's not what it was before.
It's a different use, for sure.
Yes, no doubt.
It's sort of like, it's a new purpose, so it has to go through new.
It's gonna be an occupancy change no matter what.
Well, thank you, everyone. I am going to make a motion to adjourn this meeting.
Second that.
All in favor?
Mr. Kennedy, you have